Welcome back to the Deep Dive. Today, we are taking a fascinating turn. We're moving away from what the law says about our lives and focusing instead on how the law decides what's actually true.
Exactly.
We're pulling back the curtain on the very specific and I think often surprising rules that govern evidence. It's not just enough to have the truth on your side. You have to prove it according to this hidden, complex rulebook.
That's right. Our deep dive today is really into that procedural mechanism. You can think of it as the gatekeepers of fairness.
The gatekeepers, I like that.
Yeah, we're looking at the rules that define the path any piece of information has to take to be considered factual, to be considered reliable by a court. It doesn't matter if it's a person's memory, an old contract, or, DNA results.
So these statutes we're looking at, like from Article 156 onward in the procedural rule outline, this is like the court's official vetting process.
It's the official vetting process, yes.
Okay, so let's unpack this. Before we get into all the deadlines and the paperwork, let's start with the core philosophy. If a party submits a piece of evidence, what's the fundamental requirement Article 156 lays out?
The court starts with two things that are just non-negotiable. First, the evidence has to be intrinsically true. I mean, it must be verifiable and accurate on its face.
Okay.
And second, it has to align consistently with the specific facts the party is trying to prove. So if a party claims fact A, but their evidence actually supports fact B, well, the court has grounds to just ignore it.
So the whole structure is just there to establish the true facts.
Prioritizing the true facts, exactly. The whole thing is built around that.
It sounds like the law wants the truth, but it wants it delivered in a very specific package.
That is a perfect way to put it. The package matters just as much as what's inside. If the evidence is inconsistent or, if it was submitted improperly.
Meaning it skipped a step.
It skipped one of these crucial procedural steps, yeah. The court may just disregard it entirely. It doesn't matter how convincing it might seem to you or me outside the courtroom.
Wow. Okay, that moves us perfectly from the philosophy to the rigid mechanics of it all.
Wow.
We have to talk about deadlines, especially for witnesses. This is where it gets really interesting.
Oh, this is critical. And it often trips up even experienced lawyers. The rules are, they're uncompromising. A party has to submit a list of witnesses.
And we should probably pause there because witness doesn't just mean a person, right?
Right. That's a fantastic point. In this legal context, a witness isn't just someone who saw something happen. It includes human witnesses, sure, but it also includes physical evidence.
Like what?
Documents, photographs, the actual physical objects you plan to introduce.
So a signed contract is treated with the same procedural reverence as a person giving testimony.
Absolutely, because both are pieces of evidence that the other side needs to be able to prepare for and scrutinize. And this master list, with people and objects, it has to be submitted before the trial day starts.
And what is that specific deadline? The big one.
The crucial requirement is that the list must be submitted and the request to examine them filed no less than 7 days before the scheduled date.
7 days.
7 days. It's the cornerstone of fairness. People call it the rule of notice.
In a complex case, 7 days seems incredibly tight. I mean, if you're talking about a huge corporate fraud case with hundreds of documents, how do you prep for that in just a week?
That's a great question because the whole point of the rule is to prevent what lawyers call trial by ambush. 7 days is the mandate because it ensures the opposing party has a reasonable chance to know what or who they're facing and prepare.
So it's about preparation.
It's all about preparation. And in those massive cases, they're usually managed by these long pre-trial conferences that organize everything way in advance.
But what if you miss it? What if, for whatever reason, a party misses that 7-day deadline?
Generally, that evidence is barred.
Just gone.
The penalty is strict because the system values that procedural fairness so highly. But there is a very narrow safety valve built in.
Okay.
The court can grant an extension, but only if the failure was due to some documented unforeseen circumstance, something totally outside the party's control.
Oh.
Or if the court decides that barring the evidence would actually contradict the entire purpose of justice, but you really can't rely on that. It's extremely risky. That 7-day rule is meant to be a hard barrier.
That makes sense. It respects the process but doesn't completely sacrifice the search for truth.
Precisely.
All right, let's switch gears from people to paper. Documents, physical objects. For most of us, this is what we think of as evidence. The smoking gun memo, the contract. What does the legal process demand for submitting those?
This brings us to a really crucial legal idea. The court wants the best available evidence. So for documents, the primary rule is simple, but often really difficult to meet.
which is
You have to submit the original document.
the original, not a photocopy.
Right. Because the authenticity of copies, even really good ones, is always easier to challenge.
So that's the best evidence principle in action. But what if the original is, say, held by a bank, or it's just too fragile to bring to court?
Exactly. If the original is legitimately held somewhere else, or if there's a compelling reason approved by the court, then a certified copy might be accepted.
So there are workarounds.
There are, but the court needs that assurance that the copy is a perfect reproduction. That's why certification is so important. The goal is always to minimize any chance of forgery or alteration.
And I remember reading something about a very serious consequence if you fail to provide a document you're known to have, especially if it looks like you might have, destroyed it.
Oh, this is where the court uses procedure as a tool for justice. It's a principle called adverse inference.
Adverse inference.
Yes. If a party is required to submit a key document but they fail to do so, or worse, they're found to have destroyed it or hidden it, the court can just accept the opposing party's version of what was in that document as fact.
Wow. So if a CEO shreds an email, the judge might just rule based on what the other side says was in that email. That is incredible power.
It's immense, and it shows you just how seriously the law takes document preservation. The law is basically saying, if you hide the evidence, we assume you're hiding it because it hurts your case.
So the other side gets to claim the worst case scenario for what was in there.
Pretty much. And if a document's authenticity is questioned later on, the court has procedures to order verification, including forensic analysis of the ink, paper, all of it.
That is a great segue. We've done people and paper, now let's talk professionals, experts.
Sure.
When we need specialized knowledge from, say, forensic scientists or doctors, how does the system handle their input? What's the timeline?
Well, when a party needs that kind of specialized knowledge, they have to follow a much stricter protocol. The request has to clearly state the specific objective, why it's necessary, and the exact type of scientific procedure required.
To make sure the court isn't ordering some, wild fishing expedition.
Exactly. No speculative research.
And crucially, do these scientific requests have the same 7-day deadline as general witnesses?
No, and this is a key difference that really reflects the complexity. Requests for forensic or scientific examination must generally be submitted at least 15 days before the scheduled witness examination.
15 days, so more than double the notice. Why the extra time?
Well, think about what a forensic exam actually involves. It's not just scheduling a phone call. It often means external labs, a complex chain of custody for the evidence, maybe even destructive testing.
And the other side needs to respond.
The other side needs time to get their own expert to do a counter-analysis. That 15-day alert gives enough time for the court to organize it, for the expert to finalize the report, and for the opposition to prepare a real critique.
That makes perfect sense. The more technical the evidence, the longer the lead time.
Yeah.
What about experts who are just offering a professional opinion, like a doctor or an engineer?
Those experts can submit their opinions in writing in what's called an expert report. And the court scrutinizes these very heavily. The weight their testimony gets depends on their expertise, of course, but more importantly, on the basis for their opinion.
The data they used.
The data, the methods they used, and how relevant it is to the case. The court won't just take an expert's word for it. They have to show their work. And just like any other witness, they are always subject to cross-examination.
Okay, so we've covered how you get the evidence in. But what happens next? Once it's in the court's hands, how does a judge decide its actual value?
This is the big difference between admissibility and weight. Admissibility is procedural. Did you follow the 7 or 15-day rule? Is it an original document?
It's a checklist.
It's a checklist. But weight is judgmental. It's the judge asking, how much should I rely on this information? The court considers what's called its probative value, how much it truly helps prove the point.
And what factors does the judge use to figure that out? It sounds like it goes way beyond just checking if a document is real.
It does. The court looks at a few key things. First, the inherent credibility and reliability of the evidence itself. Second, the nature and condition of it. For instance, a document found locked in a safe carries more weight than one pulled from a dumpster.
Right. Context matters.
Context is everything. They have to connect the evidence to the whole story of the case.
And what about that fourth factor, the one that's often debated?
Yeah.
How was the evidence acquired? If it was obtained through deceit, does that make it unusable?
Not automatically unusable, no, but it dramatically impacts its weight. The circumstances of how it was obtained are a critical factor. If it was acquired through illegal means, it might still be admissible if it proves a critical fact.
The court still wants the facts.
The court wants all the facts on the table, but its probative weight will be significantly reduced. The system is trying to balance things. It reserves the right to hear the truth, but it punishes improper methods by assigning less credibility.
It sounds like the judge has enormous discretion in this final phase, even after everyone has followed all the procedural rules.
They absolutely do. The law really encourages the judiciary to evaluate the evidence comprehensively, connecting every deadline, every document to the larger context. They have to uphold the fairness of the procedure while never losing sight of the main goal, finding the truth and serving justice.
This has been a complete tour of that hidden rulebook. So let's summarize the key takeaway for you, the listener. Legal procedure isn't just bureaucracy. It's a tightly wound framework of deadlines and rules designed to make sure that when the court finally weighs the facts, it's relying only on verifiable, tested information.
And if we connect this to the bigger picture, all these strict rules, the 7-day deadlines, the need for originals, it's the legal system's attempt to balance two competing things: the need for due process and the challenge of processing tons of evidence without crippling the courts.
And that leads to a final provocative thought for you to carry forward. The incredible power of a procedural deadline means that in the courtroom, the difference between success and failure can sometimes come down to whether a single, crucial document was submitted 7 days before a hearing or just 6. That is the definition of process shaping reality.